Good afternoon. It's morning in Hawaii. Uh, I'm Susan Arnett. I'm a retired criminal defense lawyer from the Public Defender's Office in Honolulu, and I also teach at the William S. Richardson School of Law at the University of Hawaii. And when you introduce yourselves, please do so clearly because I can't read your names from here.
Good morning for me. Good afternoon for you, I imagine. My name is Anthony Miller. I am an alumni of the program. So I competed my senior year of high school. I also was a coordinator for the last 10 years, and this is my first year as a judge at the national tournament. So I'm really excited to be here and hear what you have for us today.
So it is good afternoon for me. My name's Angie Levy. I'm a trial lawyer from Baltimore, Maryland. And I also teach at both of Maryland's law schools, the University of Maryland and the University of Baltimore.
Please introduce yourselves and your teacher.
I'm Bryn Burton.
I'm Isaac Otto.
And I'm Sarah Gonda, and we are Unit 4 from Sheridan High School. Our mentors are Kim Ferguson and Michael Thomas.
Thank you. And with question 1. Would be inconsistent with the constitutional separation of the executive and legislative powers to let the prerogative, pardon power, be exercised by the latter. What were the framers' reasons for giving the president the pardon power, and do you agree or disagree with them? According to the framer James Wilson, if the president abuses the pardon power, he can be impeached and prosecuted. Do you agree with Wilson? Why or why not? Your opinion, what constitutes high crimes and misdemeanors?
Alexander Hamilton declared in Federalist 70 that a feeble executive implies a feeble execution of the government, and a government ill executed is, in practice, a bad government.
With ultimately unchecked power to pardon, our panel disagrees with the framers' decision to allow one individual the power of pardoning. Originating from King Ine of Wessex and echoed by British Parliament, the Statute of 1533 declared,
"The King's Highness, his heirs and successors, kings of this realm, shall have the whole and sole power and authority of pardoning."
In relation, Alexander Hamilton expressed, "I believe the British government forms the best model the world has ever produced." Thus, foreign governments were widely taken into consideration, leading to the addition of the pardon power in Article 2 of the Constitution.
Moreover, Rufus King cautions against a mob mentality, exclaiming, "A legislative body is utterly unfit for the purpose. They are governed too much by the passions of the moment."
In contrast, George Mason argues, "The president ought not to have the power of pardoning because he may frequently pardon crimes which are advised by himself. If he has the power of granting pardons before indictment or conviction, may he not stop inquiry and prevent detection?"
George Mason's worries were put on display in 1974 when President Ford granted a full, free, and absolute pardon unto Richard Nixon for all offenses against the United States. Yet James Madison questions, "Shall any man be above justice? Above all, shall that man be above it? Who can commit the most extensive justice?"
Thus, Thomas Paine claims, "We have it in our power to begin the world over again." In the case of the pardon power, the Founding Fathers should not have modeled our constitutional government on outdated British law.
Even so, James Wilson argued, if the president be connected in any suspicious manner with any persons, the House of Representatives can impeach him.
Nonetheless, in contrast with James Wilson's belief, our panel argues that a president cannot be impeached and prosecuted on claims of the abuse of the pardon power.
Case in point, Article 2, Section 2 of the Constitution outlines, "The President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment."
Furthermore, in 1866, the Supreme Court ruled in Ex parte Garland, "The power of pardon conferred by the Constitution upon the President is unlimited except in cases of impeachment."
Consequently, the claim that the pardon power goes unchecked was upheld 5 years later in the case United States v. Klein, with the court ruling authorizing the president to offer pardon on such conditions as he might think advisable. By leaving the pardon power subject to the president's judgment, it allows for minimal argument against the abuse of the pardon power.
Therefore, Wilson's claim remains invalid, both in regards to recent history and dating back to the framers. Specifically speaking, in Federalist 74, Alexander Hamilton encouraged, "Humanity and good policy conspire to dictate that the benign prerogative of pardoning should be as little as possible fettered or embarrassed."
Additionally, Michael G. Gerhardt states, the framers were familiar with the English tradition in which the phrase other high crimes and misdemeanors was understood as referring to political crimes, which were acts that caused serious injury to the states.
President Andrew Johnson's articles of impeachment stated he did unlawfully, in violation of the Constitution, issue an order in writing for the removal of Edwin M. Stanton. Likewise, Governor Morris declared at the Constitutional Convention corrupting his electors and incapacity were other causes of impeachment.
All this proves that the founders defined high crimes and misdemeanors as extensive injustice in terms of the Constitution. However, our panel agrees with Gerald Ford when he says, an impeachable offense is whatever a majority of the House considers it to be at a given moment in history.
President Bill Clinton was impeached for lying under oath, whereas President Trump was impeached first for abuse of power and second for inciting violence. All impeachment stemmed from high crimes and misdemeanors. Thus, the term includes many possible inequities determined only by the political views of the time.
Consequently, Alexander Hamilton said in Federalist 65, the trial of impeachments is equally dictated by the nature of the proceeding. This can never be tied down by such strict rules.
We are now ready to take your questions.
You give the example of the pardon of President Nixon by President Ford. And keeping in mind that the pardon necessarily presumes that the person being pardoned has committed crimes. So it's not a claim that they didn't, but a recognition that they are not going to be prosecuted or sentenced for those crimes. And in the case of President Ford, can you point to specific advantages to him of the pardon? Something that is untoward about it, or do you simply disagree with his contention that it was good for the country to put this era behind the country by pardoning President Nixon and moving forward?
I think there must have been some sort of other reason, because I do not believe Ford would have pardoned Nixon if he hadn't had some sort of benefit himself. And it was seen that it actually played a disadvantage for him when he wasn't reelected. So I think that there was something else. There was some sort of quid pro quo, and that was the reason why he pardoned Nixon.
Well, isn't the Ford pardon of Nixon the best argument sort of against changing the system? Because Ford paid a political price for the pardon, which it sounds like essentially he didn't get impeached, but he paid a significant price. His presidency is viewed as a failed presidency by virtue of his loss in '76.
However, it is seen in many cases that the presidential pardon, there is no backlash with it, such as with Bill Clinton's political pardon of Mark Rich, in which he pardoned Mark Rich following Mark Rich's wife's donation to the Democratic campaign, and there was no political backlash following that one.
Also, going back to President Ford's pardon of Richard Nixon, he did that in the beginning of his term, and that set him up for failure throughout the rest of his term. And he created the precedent that all presidents after him would wait till the end of their term to pardon people so that they would not experience that same political backlash.
That was a great response. Thank you. So it sounds like you guys are overwhelmingly against the pardon power, at least in its current form. Do you think there is any positive side of the pardon power? And if so, how would we, if we got rid of the pardon power as it exists today, how would you suggest we maintain the positive side of this? What alternative would you propose, I guess?
Well, as seen in when Johnson pardoned ex-Confederates, it was used in a positive sense there to reunite the country. And I do think in some cases it can be used as a form of fixing the country. But some of the ways I think our panel would agree on changing it would either removing it completely or making some sort of amendment that specifies what you can and can't pardon, or even provides a check on the powers, the presidential pardon power, such as the Senate would have 2/3 vote, as was originally proposed by James Madison in the constitutional debates.
What do you do about the fact, don't you think that would heighten the political divisions in the country? For example, President Clinton did not have a majority in the Senate, President Obama, during his first term. And wouldn't there just be opposition to anybody he pardoned on political grounds alone? Wouldn't that further politicize the use of the pardon power?
I think in the case of having the Senate vote 2/3, I don't think it would create more political tensions. But I do think that if you were to make an amendment specifying terms that what you can and can't pardon, then I do think that would create more political tensions.
Going off what my colleague said, the Senate could create a committee in which only a few members would help assist the president in pardoning. So then it wouldn't be whether or not the president and Congress are the same party or not.
Do you think that do we need a constitutional amendment, as Sarah just referred to, or even though the pardon power is an Article 2 power, does Congress have any Article 1 power to regulate it in any way?
As is in the Constitution, the pardon power has no check. The Article 2, Section 2 only says President shall grant reprieves and pardons except in cases of impeachment. So I think that since there has never been a case where the president has pardoned anybody in case of impeachment, all pardons presidents have done are constitutional with no check on them.
Going off what my colleague said, the judicial branch has actually upheld the presidential pardon power, such as in cases in Ex parte Garland and United States v. Klein, in which they supported that the presidential pardon power was ultimately unlimited.
Ask, so why, given that there was debate among the founders as to whether there should even be a pardon power, and it was a matter of some debate, why do you think the compromise they arrived at, if that's what it was this unlimited power?
Well, as Hamilton argues in Federalist 74, if there were to be any sort of checks on the pardon power, it would end up contradicting its purpose in the first place, seeing as the pardon power is meant to be a lifting of justice. But if you put terms and limits on it, it's completely contrary to that idea that it's an obstruction of our normal law.
Do you see the pardon power of the president as more of an individual power of the executive branch or a check on the judicial system? And does that matter at all?
I see it as more of a personal power, such as seen where many presidents will pardon people basically on their own bias. This was also seen with Bill Clinton pardoning his half-brother, Roger Clinton, in which it was just basically for personal gain and for personal bias, and it wasn't a check necessarily on the judicial branch, but instead just benefited him.
But what about President Obama's pardon of the individuals for the small amounts of drugs, when it was demonstrated that those prosecutions had largely been directed against one racial group, and there was disparate treatment of other racial groups for small amounts of drugs? Wasn't that an example of it being used to cure a judicial overreach in the past?
I think that it was a political action campaign to further his political, standing in the community that was attacked for these prosecutions. So I think that, yes, it was to overstep those judicial acts, but I also think that it was more along the lines of his personal gain after those pardons.
And I would even go further to say that, yes, in a way, it is benefiting the country and furthering us civil rights-wise and furthering our social equity. And just like I said, with Johnson, the same thing happened. It did have a way of uniting the country. So the pardon power can be used in good ways, but more often than not, it tends to be abused, as seen when Bill Clinton pardoned Mark Rich, and it was bribery.
Thank you.
Okay. That was wonderful.
Thank you, guys.
That was a very nice presentation. Your opening prepared presentation was very effective, I thought. there was a reliance and citations to authority for the positions that you were advocating. I thought that was effective and important. And I did think that you were responsive to the questions that you were asked. And right at the end there, for example, there was a different approach, I would say, at least by two of you, which I think is also effective. I don't think there has to be wholesale agreement in your responses. You were articulate, you listened to the questions and responded. I thought it was a very good presentation.
Thank you.
I go ahead, Andrew.
So I agree. It was a very, very good opening. You did a very nice job of developing the reasons historically why this was not something that they wanted Congress to have anything to do with, and sort of giving the different opinions on it. You addressed the sort of the odd question, I think personally, of what is a high crime and misdemeanor. It doesn't seem to be totally germane to the question, but it's there, and you did a good job of answering it. I thought the response to my question about President Ford paying a political price for his pardon of President Nixon, I thought that the response that that's why other presidents have waited to the end of their terms to do this was a very appropriate and responsive comeback. The reference to President Johnson's pardon of the ex-Confederates and returns of unity. All in all, just a very nice presentation. Very, very impressive.
Yeah, I have a lot of really, really positive things to say about the content of your presentation, both the prepared remarks and the follow-up questions. You were incredibly well prepared. You had a huge amount of knowledge, and more importantly, you utilized that knowledge very, very well to respond to our questions, specifically what we were asking, and give supporting evidence that actually backed up your opinions. That's the most important part of this whole process, is not just being prepared with the information, but knowing how to use that information appropriately to respond to the questions asked. And I thought you did an incredible job of that. I was also incredibly impressed with your ability to be concise and succinct. You know, we only had 8 minutes, but you guys made that 8 minutes feel like 15, which is incredibly difficult to do. I felt like we were able to get more questions asked and answered and fully answered in the time that I've seen at almost ever in my entire 10 years of working with We the People. So I was really, really impressed with your ability to respond very, very, very well and very, very rapidly.
Thank you.
Thank you.
Thank you.
And you had very good participation as well. I don't know if you guys have been spending a lot of time with each other or not, but you're really just great. I mean, really pat yourself on the back, and your teacher and your parents, because they have every reason to be very, very proud of what you guys just did.
Thank you so much.
Thank you.
All right.
Good luck.
Wonderful. Congratulations and good luck.
Thank you, guys.
Bye.